Hello and welcome to Runkle of the Bailey. My name is Ian Runkle. I'm a Canadian criminal defense and firearms lawyer. The Supreme Court of Canada just delivered a decision in a huge fight between the federal and provincial governments. Now, this is a fight over environment and environmental regulations, but more to the point, it's really a fight over who gets to decide what, who has which powers. So a lot of people have asked me to explain this one, and I'm going to give it a shot. This is the case of the Reference RE Impact Assessment Act. And reference, what that means is that the governments actually have a special power in Canada, which is that they can bring a reference case. They can say, is this particular law legal? Is this a valid law? Even without necessarily a factual basis for it. Now, as an ordinary person, you can't do this. I can't say, hey, I want to know if this particular law is constitutional. But this is a power that is explicitly given to the governments in order that they can essentially have the courts decide something in advance of an issue. So what is going on here? Well, this is based on a bit of legislation that the federal government passed that required environmental impact assessments for all sorts of projects. And the provinces, specifically Alberta, objected to this and said, no, this is giving you way too much power. This is taking power that belongs to us. And after that, just about everybody gets involved, because you can see that it's the Supreme Court of Canada with the Attorney General of Canada, Attorney General of Alberta, and then we've got all of the people who step in as interveners, which include Ontario, Quebec, New Brunswick, Manitoba, British Columbia, Saskatchewan, Newfoundland and Labrador, the Indian Resource Council, Fil-Île-Capelle Tribal Council, Pasqua First Nation, World Wildlife Fund Canada, Nature Canada, West Coast Environmental Law Association, and it keeps going and going and going. Lots of people had various opinions on this one and wanted those to be heard. So this is a big case overall. So what's the sort of underlying issue here? How do I explain what they're fighting over? Well, that takes us back to the Canadian Constitution. And a lot of people, when they think of constitutional issues, they really think of sort of personal rights issues, in the sense of things like, can the police search me? Or do I have a right to freedom of expression? Those kinds of things. But fundamentally, what a constitution is it starts out with, we are a country and here are the rules by which this country operates. And so one of the critical sections of this, and a very heavily litigated section, is this section right here, distribution of legislative powers. And this actually divides up which powers belong to the federal government and which powers belong to provincial governments. So it starts out with section 91, which is powers of the parliament. This is stuff that belongs to the federal government. So, public debt and property, regulation of trade and commerce, unemployment insurance, raising of money by any mode or system of taxation, borrowing of money on the public credit, postal service, census and statistics, militia, military and naval service and defense, and it goes on and on and on. You know, currency and coinage, navigation and shipping, legal tender, copyrights, all of these things belong to the federal government. And one of the things that these tend to have in common is that they're things that affect the country as a whole. You know, you don't want each province having to raise its own military, because that might not make a whole lot of sense. So that is instead given to the federal government, who raises an army for Canada. And then they cut $1 billion out of their budget while claiming it's not a cut. Okay, well, moving on. So there are some things that were given as powers to the provinces. And so these are things that tend to be more local. And so now I mentioned that there was taxes in the federal government. You might be saying, wait a minute, I pay taxes to the province too. Well, that's right in there. Direct taxation within the province in order to the raising of a revenue for provincial purposes, and the borrowing of money on the sole credit of the province. Means that the province, like Quebec, can borrow money for Quebec, but Canada can borrow money for Canada as a whole. Lots of these things are of more local nature. shop, saloon, tavern, auctioneer, and other licenses in order to the raising of a revenue for provincial, local, or municipal purposes. The establishment and tenure of provincial offices and the appointment of payment of provincial officers. The incorporation of companies with provincial objects. The solemnization of marriage within the province. Property and civil rights in the province, and so forth, and it sums up with generally all matters of a merely local or private nature in the province. And then there's a further provision, 92A, which is for non-renewable natural resources, forestry resources, and electrical energy. So in each province, the legislature may exclusively make laws in relation to exploration for non-renewable natural resources in the province, development, conservation, and management of non-renewable natural resources and forestry resources in the province, including laws in relation to the rate of primary production therefrom, and development, conservation, and management of sites and facilities in the province for the generation and production of electrical energy. Now, one of the problems with all of this is that it was originally drafted a long time ago and updated less long ago, but still a long time ago. So there's a whole bunch of things that are big issues now that are just not on here at all. For example, the internet is not mentioned, notwithstanding the fact that you might think that this is a big deal. There's all sorts of issues, and a critical one in this case is the environment is not mentioned. And this has become a bit of a problem in legislation because there's some circumstances where the environment might seem to be pretty provincial in nature. For example, if there's going to be a site for a garbage dump, that garbage dump isn't going to have national implications, but it might have very real implications for the people who live nearby, especially if they're dumping something like, batteries. So that seems to be more provincial. But if you want to start doing something like maybe a particular province decides that they want to take their batteries and dump them in the ocean, and now that's going to start affecting fishing and possibly international treaties and this kind of thing. So that is really a situation where now it seems like it's more of a federal issue. And the way the courts have gotten around this is basically to say sometimes it's a provincial issue, sometimes it's the federal issue, and sometimes it's both, that both can validly operate in this sphere. Now, as I mentioned, these things have been controversial, this division of powers, since the very outset and very early on, going way back. As an example, a famous example is this one. This is the margarine case. And what happens in this case is that the government decided that they wanted to ban margarine. And so they said, no person shall manufacture, import into Canada, or offer, sell, or have in his possession for sale any oleomargarine, margarine, butterine, or other substitute for butter manufactured wholly or in part from any fat other than that of milk or cream. And they decided that they could do that because they said that this was a criminal law power that they were able to do. And so the court rejected that and said, no, that's actually powers of the provincial governments, not the federal governments. So going back even as far as, 1950s and really further back than that, the provincial governments and the federal governments have been fighting over these issues. And in fact, you'll see these issues come up every time there's an election, because the federal government will promise that they will do things that are provincial government powers. And similarly, the provincial governments, when there's an election there, they will promise things like, we will fix the criminal law. Well, you're a provincial government. You can't. That's actually not your power. So why is this one an issue? Well, this one is an issue because the federal government basically decided that they were creating a system where pretty much every project needed to go to a federal impact assessment, and then they could decide whether or not that could go forward or not. And so that's a bit of a problem, because while they're allowed to do legislation about things that are within federal jurisdiction, they can't do that about things within provincial jurisdiction. And Alberta, as well as some other provinces, said, this goes too far. So let's have a look at a little bit of what the court said. This decision is 210 pages long. I'm not going to go through 210 pages because this video would be 4 hours. And while some of you would really like that, I would rather spend 4 hours on a different case if you give me the choice. So we're going to do some quick summarizing and having a look at this. So the designated projects scheme is ultra vires, and ultra vires means outside of the power of the government that tried to pass it. So in this case, it is outside of the power of the federal government, i.e., this is an unconstitutional law, is what they're saying, as its pith and substance exceeds the bounds of federal jurisdiction. Now you might be saying, why are they saying pith and substance? Pith and substance is used in these things, and it basically means the fundamental purpose of a law, like the fundamental thing that it does. This is now a term of art, pith and substance, but to an ordinary reader, it's just obnoxious. So this is so for two overarching reasons. First, the effects within federal jurisdiction do not drive the scheme's decision-making functions. Consequently, the scheme is not in pith and substance directed at regulating these effects. And we'll see when we look at the breakdown, all of the things that they look at as to what are required for decision-making in this. And you can see that a lot of it actually exceeds the federal divisions that we were talking about. So there are 4 decision-making junctures embedded in the scheme. 1, the designation of physical activities as designated projects. 2, the screening decision. 3, the delineation of the scope of the impact assessment and the factors to be considered therein. And 4, the public interest decision and resulting regulation and oversight. This scheme requires the decision maker to consider a host of factors, but does not specify how those factors are to drive the ultimate conclusion. This is going to be a problem. So they list a bunch of factors, but they don't say how they are weighed. And so there's no indication of which ones matter most and which ones matter less, which means that in theory, they could use any of them, some of which are very much outside of federal issues. So the scheme's decision-making mechanism thereby loses its focus on regulating federal impacts. Instead, it grants the decision maker a practically untrammeled power to regulate projects qua projects, so projects just as projects, regardless of whether Parliament has jurisdiction to regulate a given physical activity in its entirety. So this is the fundamental issue here. It gives the federal government power to regulate just about any project they want to, even if that project would ordinarily be the provincial government's power. In this respect, the screening decision and the public interest decision are constitutionally problematic, which is how the Supreme Court says, we're throwing this out. The screening decision as to whether an impact assessment is required for a particular project must be rooted in the possibility of adverse federal effects. However, because the decision maker must take into account an open-ended list of factors, all of seemingly equal importance, only 2 of them tied to federal jurisdiction, an impact assessment could be required for reasons other than or not sufficiently tied to the project's possible impacts on areas of federal jurisdiction. All right, let's take a little break from that to look at the actual list of factors, because that's important here. The court put a lot of importance on this list and said a lot of this is not federal government issues. So let's have a look. Let's see if we agree. All right, so factors, impact assessment. These are the factors that the government should be considering. The impact assessment of a designated project, whether it is conducted by the agency or review panel, must take into account the following factors. A, the changes to the environment or to health, social, or economic conditions, and the positive and negative consequences of those changes that are likely to be caused by the carrying out of the designated project, including the effects of malfunctions or accidents that may occur in connection with the designated project, any cumulative effects that are likely to result from the designated project in combination with other physical activities that have been or will be carried out, and the result of any interaction between those effects. Now, some of this might be federal, but some of this might be local. For example, a coal mine that might have negative consequences on people living right near the coal mine might not reach that federal level. But like a nuclear plant, where if it, explodes, might have longer or wider ranging impacts, might be a different story. This one's kind of complicated and kind of mixed. Mitigation measures that are technically and economically feasible and would mitigate any adverse effects of the designated project. The impact that the designated project may have on any Indigenous group and any adverse impact that the designated project may have on the rights of Indigenous people recognized and affirmed by Section 35 of the Constitution Act. The purpose of and need for the designated project. Alternative means of carrying out the designated project that are technically and economically feasible. So what else could you do instead of this one? Any alternatives to the designated project? So could you do something different instead? You said you wanted a coal mine. Could you instead make a park? Indigenous knowledge provided with respect to the designated project. The extent to which the designated project contributes to sustainability. The extent to which the effects of the designated project hinder or contribute to the Government of Canada's ability to meet its environmental obligations and its commitments in respect of climate change. Any change to the designated project that may be caused by the environment. The requirements of the follow-up program in respect to the designated project. Considerations related to Indigenous cultures. Community knowledge provided with respect to the designated project. Comments received from the public. Comments from a jurisdiction that are received in the course of consultations conducted under Section 21, any relevant assessment, and any assessment of the effects of the designated project conducted by or on behalf of an Indigenous governing body, and more Indigenous issues. Here's where we get to a fun one. The intersection of sex and gender with other identity factors, and any other matter relevant to the impact assessment that the agency requires to be taken into account. So literally anything else. Now, I'm just going to note, you might think some of these are really good ideas, but that doesn't necessarily mean that they are federal government powers. You might say it's great if we have mining projects hiring more women, but that's not a federal government issue. That's a provincial government issue, and the federal government can't just say, we want this power. We want this. Because the problem with that is that governments always look at power and they say, we want this. They're like the seagulls from Finding Nemo going, mine, mine, mine. That's governments. Anytime they look at a power, they say, I want that. That's my power. Gimme. And the role of the court here is to say, no, that's not your power. That power belongs to them instead. And that's really what this case is about. So, bringing this back up here, similarly, the public interest decision must focus on the project's federal effects. However, because the mandatory public interest factors are not all confined to federal legislative competence, and because some factors are framed in relation to the assessment of the project as a whole, rather than to the adverse effects within federal jurisdiction, a determination of whether adverse federal effects are in the public interest is transformed into a determination of whether the project as a whole is in the public interest. I.e., they're not just weighing the effects on federal areas of power. This is basically just the federal government getting a veto on projects based on whether or not they decide that that project is itself a good idea. And that's not the federal government's role. The federal government does not get to decide whether a provincial project is a good idea. So second, the defined term effects within federal jurisdiction does not align with federal legislative jurisdiction under Section 91, but rather goes far beyond its limits. Its overbreadth manifests itself in two distinct ways. First, the definition of effects within federal jurisdiction is central to the scheme's decision-making functions. And second, the defined effects within federal jurisdiction result in impermissibly broad prohibitions. So this means that the conduct that it bans extends far beyond the range of conduct that Parliament can validly regulate pursuant to its assigned heads of power. The Constitution gave the federal government a certain list of things that it was entitled to worry about and entitled to act on. and this goes too far. They take on too much power. So that's really what this case is about. The court says, no, you're giving yourself way too much authority. Stop it. Now, I will note there's some really interesting legislative background on this one, or procedural background, because at the Court of Appeal, the government tried a bold strategy. And I'll say a bold strategy because they were playing chicken a bit with the court. And so what happened is they went to the court and they said, hey, this legislation has to either stand on its own as an entirety, or it has to fail on its own. They said you can't pick out specific parts as constitutional and other parts as unconstitutional, and that if you disagree with any part of this, you have to throw the whole thing out. And why would they do that? Well, they would do that because they expect the court to say, you know what, fine, you can have the whole legislation as is. And that's not what the Court of Appeal did. Court of Appeal said, okay, we accept that submission. This is a cohesive scheme, and it either has to all apply or none of it can apply at all. And that didn't work out so well for them, because the ultimate result of that was that the court said, we're throwing it all out. The whole thing is unconstitutional, and start at the beginning. And so obviously they didn't like that at all. So they appealed this up to the Supreme Court. And the Supreme Court was very aware of this argument, but decided that that wasn't how they were going. Because the Supreme Court, if you tell them, listen, you have to do this, you are bound up, the Supreme Court is really able to say, no, we're not, we can do what we want. And in this case, they said, we're rejecting in part the Court of Appeal's decision. And the part is that they say, listen, the fundamental core about this is still constitutional. And that is the following sort of sections. Section 81 through 103, I think it is. Basically just to say, listen, they can actually say that you need to have all of these, these principles and rules about what's happening, but it has to be with respect to things that are federal in nature. You can't just apply this to everything, including provincial things. So this is why we're seeing decisions from both the government and the people who are fighting the government both declaring victory, because to a certain extent, they both achieved some element of win here. The federal government can come back and rework this so that it only targets aspects of federal concern. And that's still going to affect a lot of projects, because a lot of projects have environmental impacts that might extend beyond provincial boundaries or in some significant way. Whereas the provinces are pretty thrilled about this, because it's basically forcing the federal government to back off a little bit. So this is a really interesting decision, but it's also a really boring decision in a lot of ways. And when I say a really boring decision, I mean it's 210 pages of arguing about the boundaries of the Canadian Constitution and division of powers. Now, I can tell you that Professor Eric Adams, his constitutional law class, which I actually managed to enjoy because he's a fantastic teacher, even though he's teaching things like the margarine reference, this is going to be in there. Like, this will be in there, and he will make it fascinating. But I think if I did a full video going through this, that you would probably start getting a little bored. So I'm going to wrap this up here. If you've got specific questions on this one, let me know. I will try to answer them. I do try to answer some of the comments when they're sort of a relevant question there. But yeah, hopefully this has cleared things up. I know there's a lot of people out there making big comments about the huge impact of this one. And a lot of those comments are unfortunately a little misguided. There's some people who want to make this into a bigger issue than it is. And there's also people who want to make this into a non-issue, and it's neither of those things. This is an ongoing part of the fight that will continue forever between the federal government and the provincial government. And the reason why it'll continue forever is that both of them want more power than the Constitution gives them, and they're going to push against that as much as they can for the rest of time. So anyway, thank you for watching. I hope you found this one to be interesting or educational. Please like this video, share it with your friends, subscribe to see more content. I also want to thank my Patreon supporters at the $50 level: Lembus for the Elf, the CCFR, Canada's National Firearms Association, and the Canadian Shooting Sports Association. At the $20 level, Lindsay Metcalf, Larry Kalniak, Here's a Coin, Legal Witcher, Cameron Johnson, Andrew Elsich, and Vicky and Dorky Dane. Thank you as well to my $10 supporters, who will be in the crawl immediately following. Thank you for watching. Hope this has armed you with knowledge. See you next time.